Hello, everyone. This is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to this special 5-part podcast series sponsored by Affiliated Monitors, which celebrates Affiliated Monitors' 15 years in business as the first entity specializing in independent integrity monitoring. Founded in 2004, Affiliated Monitors provides independent integrity monitoring and ethics and compliance assessments nationally and internationally and across almost all industries. With its knowledge of effective ethics and compliance programs and cultures, Affiliated Monitors is respected for its work as the corporate monitor on matters ranging from multinational corporations to small and mid-sized companies and even individuals. Having served in nearly 750 monitorships, no one has more experience as an independent monitor than the team at Affiliated Monitors. For more information on how an independent monitor can help improve your company's ethics and compliance programs, visit this podcast series sponsor, Affiliated Monitors, at www.affiliatedmonitors.com. In this 5-part podcast series, I'm joined by Don Stern. Don is the Managing Director of Corporate Monitoring and Consulting Services at Affiliated Monitors. Don is a well-known white-collar corporate defense lawyer. He was previously the United States Attorney for the District of Massachusetts, has been a lecturer at Harvard, and has worked at several law firms before coming over to Affiliated Monitors. In this 5-part podcast series, we consider the benefits of independent monitoring and proactive assessments for defense attorneys. In episode 1, we take a look at how defense attorneys can proactively work with independent monitors. 2, what are the nuts and bolts? How does this thing work? 3, a couple of case studies of defense counsel who've engaged a monitor to mitigate internal issues before going to a regulator. Number 4, how this works in a medical setting. And in episode 5, we conclude by how this works in the nonprofit setting, specifically looking at some issues around varsity blues. It's a fascinating series that I know you will enjoy as a compliance specialist. This special 5-part series is a special presentation of the Compliance Podcast Network. Hello, everyone. This is Tom Fox, back again with Don Stern. Don's a Managing Director of Corporate Monitoring and Consulting Services at Affiliated Monitors. And today we're going to take a look at a specific example in the healthcare and medical setting. Don, first of all, welcome back.
Thank you, Tom.
Don, I was wondering if you have an example you could cite to us where Affiliated Monitors stepped in as a third-party independent to really help a company, a healthcare or medical facility, work through issues surrounding opioid prescriptions.
Well, I do have one example, and I think it's an example for a variety of reasons. One of which I think it shows that companies and healthcare practices these days are much more willing and anxious to be proactive rather than just wait for the next problem to arise. And I think that's a very healthy thing. And the example I have in mind is a medical practice, not a insurance program or a big hospital chain, but a fairly significant medical practice somewhere in the Midwest. And they had one of their physicians who eventually was investigated by the various licensing boards in that particular state for excessively prescribing opioids. So, I think that if this had happened a couple years ago, I think it's likely that the medical practice would have said, we've got a bad apple. This is a problem. This is a rogue employee. But, we did everything, we could to mitigate the problem. We cooperated with the government. We fired the physician. But what happened instead, which I view as a good thing, the people who run the medical practice said, we think it's a rogue employee. We think it's a one-off situation. The government's not asking us to do anything more, but we think, particularly given the severity of the opioid crisis or in our area and around the country for that matter, we're going to bring in a third party to assess our compliance program more generally. We know what happened here. The question is, how are we doing more generally? And have we provided the guardrails and the internal mechanisms to not only reduce the risk that this is going to happen by somebody else, but to encourage people to come forward, encourage nurse practitioners to come forward, to encourage people who keep the medical records for our practice to come forward, and for us to follow up and investigate. So that's what we've been doing, and we'll report back to the company, and I think at the end of the day, it will be not only a better medical practice, one that is more protective of the physicians in general, of the owners of the practice, but for that matter, for the public. And I think that's a good story, one that shows that people running this medical practice are responsible and want to do the right thing.
Don, I was really intrigued in your opening remarks on this case study where you said that perhaps a few years ago, a cooperating healthcare provider or company would have done something along the lines of doing an investigation, finding an employee who violated the company's compliance program, and then terminating that employee, turning those results over to the government. But now you're talking about really an entire new step that the company took, which is to bring in a true independent third party to make an assessment. And it sounds like that is, if not a best practice, certainly a more effective way for companies to get a handle on this and work in partnership with the government to try to slow down or stop this crisis.
I think that's true. I mean, I think, no one wants to be the next, part of it is just being smart and kind of thinking ahead. I mean, the Me Too movement is probably a good example of that. When things happen in a particular company and they're the front page of the Wall Street Journal, the New York Times, I think it's kind of foolhardy to think that somehow, there's no conceivable way in which your company could also run afoul of similar issues. So, I mean, again, I think it's smart. I think boards, audit committees of boards and compliance committees of boards are much more apt these days, I think, to say to management, I've read about X. What are we doing? I want to report. I want to find out how we're doing and how we're mitigating the risk in this particular area. Because, as you know, Tom, the cost of getting it wrong these days is very, very high. It's not just the cost of hiring some lawyers to defend you with a government agency, Department of Justice or something. It's not just, the reputational risk. But if you're a public company, your stock price is probably going to take a nosedive if there's a problem in this particular area or other areas. So it's a fairly prudent and cost-effective step to try to get ahead of the situation. And, I think you could do some of this with a very good internal compliance program and an internal audit program. But I think the best way to do it, to add to what you already have, I think, is to have a third-party assessment.
Don, you have listed a couple of different reasons to bring in a third party. Earlier in a prior episode, you talked about how it lends credibility and support to employees when they see a truly independent come in and talking to them. You talked about how it can lend credibility when you're sitting across the table from a regulator or the government. But now you've really given us a third reason, which is just overall risk management. And that a proactive approach can, you didn't say this, but it seemed to me to be very close to saying this is really a business advantage to take this proactive approach. Once again, would that be a fair assessment?
I think so. I mean, again, most responsible companies these days are assessing their risk, the enterprise risk, and the more they look around and look at the landscape, I think they see that the best way to do this is to kind of assess their own situation. It's very tempting if you're in a competitive environment, if you're a financial institution or you're a medical institution, and one of your competitors gets into trouble in a particular area, it's very tempting to sort of self-righteously say, gee, maybe that's a good thing for me, right? Because they're in trouble. I'm going to be able to take away some of their market share because people aren't going to go to them. And that may work in the short run, but in the long run, you're better off saying, gee, maybe they're not so unique. Maybe I need to look internally. Maybe we need to look at the mirror and see what's going on. Again, I mentioned in one of the earlier, the Me Too movement. I mean, it's been very common for companies and private schools and other institutions to take a look at themselves, sometimes going back historically, and that's not the work that we do. That's typically done by a group of white-collar lawyers who kind of go back and do an internal investigation. But to sort of assess what happened in the past, where we come in is we work with the company at benchmarking and coming up with best practices, because we think most companies want to kind of have a state-of-the-art best practice rather than simply rely upon what worked 5 years or 10 years ago.
So, Don, in the situation where you do come in on this proactive basis, are you really given an assignment to look for something, or are you given not necessarily free rein, but are you allowed to use your own professional judgment and discretion to test, to ask questions, to probe, and to really fully assess where a compliance program or specific issue might be?
Well, there's some variation, I have to say, and I don't think this is bad. So, in some instances, the company has an inkling based upon its internal audit or based upon some other information as to the problem. And, they certainly don't want to sort of willy-nilly spend huge amounts of money for us to review their antitrust problem, their program, their EEO problem, their FCPA program. So sometimes it's more focused. So it could be, for example, in the pharmaceutical area, they may know that they have a problem with their sales and marketing effort, and so that could be the focus. But I have to say, inevitably, we get a sense of the culture of the company that even no matter what the entry point is for us to be talking to the employees and for the company management, typically we'll get some insight as to some broader issues. And sometimes we'll do it just like that. We'll say, we know you brought us in to look at X, and here's what we're going to put in our report back to you. But by the way, we also have some other observations which we want to pass along to you, and you can do with what you want with that. But here are our observations. And I have to say, generally, they're greeted very enthusiastically, like, thank you very much. We didn't really know that. This is helpful to us, and we're going to sort of weave that into our compliance program going forward. We think that's an added value which we can provide to companies.
Well, Don, unfortunately, we are near the end of our time, but I hope you will join us tomorrow for our final episode, where we take a look at third-party independent monitoring in the nonprofit and educational space. Don, I look forward to continuing the conversation in our next episode.
Great. Thanks, Tom.
Hello, everyone. This is Tom Fox again. I hope you enjoyed this episode of my visit with Don Stearns on the benefits of independent monitoring and proactive assessments for defense attorneys. If you'd like more information on Affiliated Monitors, please check out their website, www.affiliatedmonitors.com. This 5-part podcast series is a special presentation of the Compliance Podcast Network. Thank you again, and I hope you will join us for another episode.